Okay, good afternoon, everyone, and welcome to this webinar on the UK's nuclear arsenal and the legal opinion on that. My name is Kirsten Oswald. I am the Chair of Parliamentary CND, and I'm delighted to have with us today Professor Christine Chinkin and Dr. Louise Arimatsu, as well as Dr. Kate Hudson. So we look forward to hearing what they all have to say and also to hearing from you. There will be an opportunity for a Q&A after we've heard from our speakers, and the information which pertains to the legal opinion will be made available after this event. So with no further ado, I will move first of all to Christine as our first speaker. Welcome, and over to you.
Thank you, Kirsten, and thank you for that introduction and for the opportunity to talk about the opinion that Louise and I wrote together. We were asked to give the opinion on the legality under public international law of the UK's nuclear policies as were announced in the March 2021 integrated review. Specifically, its twofold stated intention to increase its overall nuclear weapon stockpile from 180 to 260 warheads, and to update its nuclear deterrent system by replacing its existing nuclear warheads with modern nuclear systems. And the further somewhat strange statement that the UK will not use or threaten to use nuclear weapons against any non-nuclear weapon state party to the Treaty on Non-Proliferation of Nuclear Weapons, the NPT. This assurance does not apply to any state in material breach of those non-proliferation obligations. However, it continues, we reserve the right to review this assurance if the future threat of weapons of mass destruction, such as chemical and biological capabilities, or emerging technologies that could have a comparable impact makes it necessary. So these policy announcements in the integrated review raise issues of treaty law, customary international law around the NPT, the Non-Proliferation Treaty, the UN Charter, international humanitarian law, environmental law, and human rights law, many of the most important areas of contemporary international law. And we broke it down into three questions. First, does the announcement by the UK government of the increase in nuclear warheads constitute a breach of the NPT Article 6? Second, would the UK be in breach of international law were it to use or threaten to use nuclear weapons against a state party to the NPT that is itself in material breach of its own obligations under the NPT? And third, would the UK be in breach of international law were it to use or threaten to use nuclear weapons in self-defense where a future threat of weapons of mass destruction could have comparable impact to nuclear weapons? So I will briefly outline our response with respect to the NPT and then hand over to Louise, who will move on to the issues relating to the use of force. Now, if any of you have looked at the opinion, you'll know it's long. It has many legal technicalities and legal details that we cannot possibly go into in the 15 minutes or so that we've got to talk about it. So what we will do is try and give a distillation of the main arguments, keeping away from the legal technicalities. But of course, we'll be happy to go into more detail on the legal issues if asked during the question session following our presentations. So, is the UK in breach of the Nuclear Non-Proliferation Treaty, NPT, Article 6? The UK has been a party to the NPT since 1968. The treaty came into force in 1970, so the UK is legally bound by the treaty. Treaty covers three main pillars: non-proliferation, peaceful use of nuclear energy, and disarmament in Article 6. And so Article 6 sets out the obligations on state parties to pursue negotiations in good faith on effective measures relating to three specific results: cessation of the nuclear arms race at an early date, nuclear disarmament, and a treaty on general and complete disarmament under strict and effective control. Article 6 applies to all states parties to the NPT, although it's primarily directed at the obligations of the nuclear weapon states, those states that by 1968 had already acquired nuclear weapons. And the negotiation history of the treaty makes it apparent that Article 6 is a core component. It was not an add-on provision. it gives effect to what is being called the strategic bargain between the many states that renounce through the treaty future acquisition of nuclear arms and those states that already then possess them, the nuclear weapon states. And I think it's worth noticing that the UK does not deny the applicability of the NPT to itself. Indeed, to quote the integrated review, it states, "We are strongly committed to full implementation of the NPT in all its aspects, including nuclear disarmament, non-proliferation, and the peaceful uses of nuclear energy. There is," it says, "no credible alternative route to nuclear disarmament." So on the one hand, we have the UK's stated and continued commitment to the NPT. On the other, its expressed intention to increase its nuclear warheads and modernize its system. So is this a breach? And to determine this, we have to determine the scope of the legal obligations through interpretation of Article 6, and then determine whether its behaviour is in conformity with those obligations. Now, international law provides a number of principles on treaty interpretation. Essentially, it provides that a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to its text in their context and in light of its object and purpose. So three crucial elements for interpretation: ordinary meaning, context, and object and purpose, and that these should be taken holistically as a whole. And in addition to the text of the article, some reference may be made to further materials to elucidate the context. These include the preamble to the treaty and any subsequent agreement between the parties regarding the treaty's interpretation or application, or any subsequent practice that establishes the agreement of the parties with respect to interpretation. Now, this last provision, agreement practice, allows for reference to the NPT review conferences that are held at 5 yearly intervals to ensure that the purposes of the preamble and the provisions of the treaty are realised. And subsequent declarations and decisions of the review conferences may be precisely such a subsequent agreement or give rise to subsequent practice, and are thus irrelevant for interpretation of the NPT. And especially significant is the 2000 review conference, where the parties agreed practical steps for the systematic and progressive efforts to implement Article 6 that were reaffirmed in 2010 review conference and supplemented by the action plan on disarmament. These, therefore, are relevant in interpretation of NPT Article 6. The objects and purposes of the NPT with respect to disarmament are made explicit in the preamble, where the parties declare to, quote, their intention to undertake effective measures in the direction of nuclear disarmament, and to this end, they undertake to pursue negotiations in good faith. So we have the ordinary meaning, the context, including the review conferences and the practical steps for parties to the NPT to achieve implementation of the treaty that were agreed in 2000 and have not since been either disapproved or rejected. And we have the object and purpose as set out in the preamble. So the next step must be to determine what behaviour constitutes violation of Article 6, and more specifically, whether the UK's actions constitute such breach. Now, international law provides two routes to determine whether or not there's been breach of a treaty. Under treaty law, there is the commission of material breach, or more generally, under what is termed the law of state responsibility, a state's responsibility for the commission of an international wrongful act that includes breach of the treaty. First, material breach. Material breach occurs where there is behaviour that violates a provision essential to the accomplishment of the object and purpose of the treaty. So what is relevant here is the importance of the provision violated, not the intensity or seriousness of the breach. It requires that the provision breached be essential for the accomplishment of the treaty's object and purpose. And as I have just explained, the NPT preamble describes the treaty's objects and purposes, including to undertake effective measures in the direction of nuclear disarmament. These can then be considered in interpreting the ordinary meaning of the treaty text. And the linkage between the principles of non-proliferation and the obligation to negotiate towards nuclear disarmament is confirmed by the NPT negotiation history that can be referred to in order to confirm the meaning to be given to the provision, Article 6, as well as the final documents of the 2000-2010 review conferences, which are also applicable as subsequent agreement or practice. So we conclude that Article 6 is a provision essential to the accomplishment of the object or purpose of the treaty, and therefore breach of that provision would constitute a material breach of the NPT. But in addition to the concept of material breach, the International Law Commission, now this is the body that is responsible under international law for codification and progressive development of the international law, has also considered breach. It defines the existence of a breach of an international obligation as occurring, quote, when an act of that state is not in conformity with what is required of it by that obligation, regardless of its origin or character. So this requires asking whether the behaviour in question was in conformity with the treaty requirements. This can be at any level of non-conformity. There is here no qualifier such as material breach. And in the words of a leading commentator, this is flexible enough to encompass all forms of breach, whether the underlying obligation requires compliance with strict and detailed requirements, whether it merely sets a minimum standard of conduct, whether the breach completely disregards the obligation or is only partly contrary to what is required. A determination of whether there has been a breach is achieved in all cases by comparing the conduct in fact engaged in by the state with the conduct legally prescribed by the relevant primary obligation. And if the state behaviour is not in conformity, the state is responsible for the breach of the treaty in question. So that's the law, very briefly. And the final step is to determine whether the UK policy with respect to increasing its nuclear warheads is in accordance with its obligations under NPT Article 6, and more generally, its obligation to act in good faith. So to look at the UK behaviour, again, very briefly. In 2010, the UK government stated that it would, quote, reduce the number of warheads from 48 to 40, in line with our commitment vigorously to pursue multilateral global disarmament and reduce our overall nuclear warhead stockpile ceiling from not more than 225 to not more than 180 by the mid-2020s. In 2015, at the review conference, the UK delegation head stated that the United Kingdom remains firmly committed to step-by-step disarmament and our obligations under Article 6. In 2019, a national report was prepared, ready for the 2020 review conference, which of course has been postponed until August of this year because of the pandemic. The UK stated back in 2019 that the UK, as a responsible nuclear weapon state, has been pursuing a step-by-step approach to nuclear disarmament consistent with the NPT and our other treaty commitments. We have committed to reducing our nuclear weapons stockpile to no more than 180 by the mid-2020s, and we have achieved our target of reducing the number of operationally available warheads to no more than 120. But then, in March 2021, using the evolving security environment as its justification, it changed its position to move to an overall nuclear weapon stockpile of no more than 260 warheads, a complete reversal in policy that has occurred for the first time since the end of the Cold War, that the UK has sought to increase its stockpile. Now, this unilateral announcement of an increase in the stockpile of nuclear weapons is, we think, not in conformity with the conduct legally prescribed by the NPT Article 6 to undertake effective measures towards nuclear disarmament, a provision that is essential to the accomplishment of the object or purpose of the treaty. Further, state parties to the NPT undertake to pursue negotiations towards nuclear disarmament, an obligation to be performed in good faith and characterized by the International Court of Justice as an obligation of result. A unilateral assertion of intent to increase its stockpile of nuclear warheads and to modernize its weapon system indicate a position contrary to a good faith intention to negotiate. The assertion of commitments that are then disregarded, apparently at will, is not in accordance with good faith. We conclude, therefore, that the UK is in breach of NPT Article 6 under both treaty law and the law of state responsibility. And this assessment corresponds with the statement made by the Office of the UN Secretary General, which described the UK's decision to increase its stockpile as, quote, contrary to its obligations under Article 6 of the NPT. This breach of the NPT Article 6 by the UK incurs state responsibility. And I think in this context, it is worth noting that in 2017, the UK made a further reservation to its declaration accepting the compulsory jurisdiction of the International Court of Justice under the statute of the court. Now, this was following the case brought the Marshall Islands against the United Kingdom with respect to Article 6 that was dismissed by the court on grounds of inadmissibility. The reservation states that the UK does not accept the jurisdiction of the court in, quote, any claim or dispute that it arises from or is connected with or related to nuclear disarmament and or nuclear weapons, unless all of the other nuclear weapon states parties to the NPT have also consented to the court's jurisdiction and are party to the proceedings in question. So this reservation seeks to ensure that the obligations under the NPT Article 6 cannot be objectively adjudicated upon by the ICJ, which is the principal judicial organ of the United Nations, unless the other nuclear weapon states have also accepted the court's jurisdiction. Now, the UK is, of course, entitled to make reservations to its acceptance of the jurisdiction of the court, but it doesn't sit well with an obligation to pursue in good faith negotiations towards effective disarmament. In addition to the NPT Article 6, the nuclear policies must also be assessed for their conformity with other legal regimes relating to the use of force that Louise will now address: international humanitarian law and environmental law. So over to you, Louise.
Thank you so much. That was incredibly helpful and interesting, and I'm sure that that's given us a great deal of food for thought. And Louise, we look forward to hearing from you now.
Thank you. So in the allocated time, I'm going to speak to questions 2 and 3 that Christine read out earlier. And the first issue that I address is the consequence of a material breach of the non-proliferation obligations under the NPT. And I want to begin by emphasizing that material breach by a state party of its non-proliferation obligations alone does not give rise to the right of a state to use or to threaten to use nuclear weapons. Under the law of state responsibility, a breach may permit a state to take countermeasures, but such measures do not include the right to threaten or to use force. In international law, only an armed attack gives rise to a right to use force in self-defense. Now, as you all know, the UN Charter Article 2.4 prohibits the threat or the use of force. The prohibition is a norm of customary international law and widely regarded as jus cogens. Article 51 of the Charter provides that self-defense is an exception to the prohibition of the use of force. The right to self-defense is also a customary exception, and is also a customary exception to the prohibition. Now, the conditions precedent for lawful use of force in self-defense is an armed attack, and this is made clear by the text of Article 51. This is also confirmed by the ICJ, which has repeatedly noted that force used in self-defense in treaty and customary international law is, quote, subject to the state concerned having been the victim of an armed attack. A state confronted by an armed attack, irrespective of the means and methods used, is entitled to resort to the use of force to repel the act or to bring an attack underway to an end. Sorry. Sorry, I've lost my space now, of course, online, which is a little bit embarrassing. So the means and methods used may be relevant as facts to determine whether the force constitutes an armed attack. Now, there is no disagreement that an armed attack gives rise to the right of self-defense. The question is, what constitutes an armed attack? Now, some cases are easy, some are not. The ICJ has nevertheless given some guidance and has noted that to qualify as an armed attack, the scale and effects of a use of force must be grave, but precisely what that threshold is remains unsettled. For that, we need to look at state practice. Now, even if the use of force is justified as an exercise in self-defense, it is restricted by the conditions of necessity and proportionality. These are customary international law requirements. Necessity requires that a use of force is only such force needed to successfully repel an imminent attack or to bring to an end one that is underway, and that non-forceful measures are insufficient to do so. Proportionality requires, the requirement limits the scale, scope, duration, and intensity of the force that can be legitimately used to achieve the goal once force is deemed necessary. Now, opinions continue to differ on whether self-defense is permissible only once an attack has been launched, or whether the state may resort to force in self-defense once an armed attack is imminent. The latter view, anticipatory self-defense, is the dominant view, although not all legal experts agree. Preemptive self-defense, which is sometimes referred to as the Bush Doctrine, has been roundly rejected. Now, turning to the review, the UK has signalled that the threat of, quote, chemical and biological capabilities and emerging technologies as triggering the right to use or threaten to use nuclear weapons in self-defense. Now, the first point to note is that the right to use force is not contingent, as I've said, on the type of weapon that a potential adversary may deploy. The condition precedent, as I've made clear, is an armed attack, irrespective of the means and methods used. It follows that the UK would be in breach of international law were it to use or threaten to use nuclear weapons in self-defense if the threat confronted did not constitute an armed attack. In fact, the UK's practice supports this understanding. Take, for example, the government's response to the use of Novichok by agents of the Russian Federation in 2018 in Salisbury. There was consensus that while the use of chemical weapons was deemed to be in violation of Article 2.4, the attack did not necessarily reach the threshold of an armed attack. This conclusion is evidenced by the measures taken by the UK in response, which included a formal statement condemning the attack as, quote, a breach of international law and a violation of the Chemical Weapons Convention, the issuing of arrest warrants, diplomatic expulsions, and the imposition of targeted sanctions. In other words, we're talking countermeasures, not force. Now, returning to the integrated review, the UK also states that, quote, we would consider using our nuclear weapons only in extreme circumstances of self-defense, including in defense of our NATO allies. Now, we can discuss the issue of collective self-defense if anyone would like to do so in Q&As, but for the moment, my focus, or I'd like to focus on individual self-defense. In the event that the UK was indeed about to be attacked or had been the subject of attack, and the attack met the threshold of being an armed attack, The contemplated use of nuclear weapons in self-defense would have to be the only means to successfully repel an imminent or an armed attack, or to bring to an end one that is underway. In addition, the use of nuclear weapons would need to satisfy the proportionality requirement. In its advisory opinion, the ICJ questioned whether the use of nuclear weapons would satisfy the proportionality criteria. The devastating effects of nuclear weapons in terms of scale, scope, duration, and intensity are such that it would seem highly unlikely that the criterion of proportionality would be satisfied. The integrated review also refers to a future threat, and notwithstanding the existing differences over the imminence criterion, the existence of an undefined future threat does not give rise to the lawful use of force in self-defense. At a minimum, the anticipated armed attack must be imminent. Now, although the ICJ was unable to agree to a definitive position on the use of nuclear weapons in, quote, extreme circumstances of self-defense in which the very survival of a state would be at stake, it nonetheless reminded states that even if lawful under the legal regime pertaining to the use of force, the use of nuclear weapons must also comply with other international legal regimes that continue to apply concurrently. And these bodies of law include international humanitarian law, the laws of armed conflict, international human rights law, and environmental law. Now, IHL, international humanitarian law, is a body of law that applies in situations of armed conflict. The UK is a state party to the core IHL treaties, including the 1907 Hague Conventions, the 49 Geneva Conventions, and the 1977 additional protocols. Now, it should be noted that on ratification of Additional Protocol 1, the UK entered the following declaration, quote, that the rules introduced by the protocol apply exclusively to conventional weapons without prejudice to any other rules of international law applicable to other types of weapons. In particular, the rules so introduced do not have any effect on and do not regulate or prohibit the use of nuclear weapons, end of quote. Now, notwithstanding the reservation, the vast majority of IHL treaty rules are recognized as being of customary international law status and thus apply whether or not the state is a party to the treaty. The ICJ has described the principle of distinction and the principle on the prohibition of unnecessary suffering as cardinal and intransgressible principles of customary international law. In its advisory opinion, it stated these fundamental rules are to be observed by all states, whether or not they have ratified the conventions that contain them, because they constitute intransgressible principles of international customary law. In fact, the president of the ICJ also expressly stated that a use of force, even exercised in extreme circumstances in which the survival of the state is in question, cannot allow a state to exonerate itself from compliance with these intransgressible norms. Now, the customary international principle of distinction requires that parties to the conflict distinguish between civilian population and combatants and between civilian objects and military objectives at all times. The principle of distinction is the founding principle upon which many of the specific IHL rules are based, including the rule of proportionality, the requirement to take precautions in attack, and is also the principle that informs the rules pertaining to the means and methods of warfare. It is at the core of the prohibition of indiscriminate attacks, which outlaws attacks that are of a nature to strike military objectives and civilians or civilian objects without distinction. Such attacks include the use of weapons that cannot be directed at a specific military objective or that have effects that cannot be limited as required by IHL. Each of these rules represent customary international law. Now, there are serious doubts as to whether nuclear weapons can be used in accordance with these rules. They are designed to disperse high heat, blast effects, and radiation, and in most scenarios, their effects could not be restricted in time or indeed in space. In fact, the ICJ noted that given the unique characteristics of nuclear weapons, their use, quote, seems scarcely reconcilable with the respect for the distinction or indeed the prohibition on unnecessary suffering. The IHL rule of proportionality requires that for an attack to proceed, the foreseeable incidental impact on civilian and civilian objects may not be excessive in relation to the concrete and direct military advantage anticipated. In practice, this means calculating the immediate civilian deaths and injury, damage and destruction to civilian objects that are expected to result from the use of the weapon, including nuclear, as well as the foreseeable long-term effects of its use, such as radiation, and the impact on other critical infrastructure essential for the survival of the civilian population and arguably the ecosystem. Again, given the scientific evidence that's now available, it's highly unlikely that direct and indirect effects of the use of nuclear weapons would not be excessive to the concrete and direct military advantage anticipated. It follows that any use by the UK would more likely than not violate IHL's proportionality rule. IHL prohibits the use of weapons of a nature to cause unnecessary suffering, meaning suffering that is out of proportion to the military advantage sought. The prohibition is both customary international law and a treaty law, which applies to combatants, members of organized armed groups, and civilians directly participating in hostilities. In addition to the immediate suffering caused, scientific studies show that a nuclear explosion will generate high doses of radiation, which have devastating immediate and long-term consequences to health of the exposed individuals, including damage to the central nervous system, to gastrointestinal tract, and an increased risk of developing certain cancers such as leukemia and thyroid cancer. The ICRC's Director of International Law and Policy notes that the short and long-term illnesses, permanent disability and suffering caused by radiation exposure, quote, raise serious questions about the compatibility of nuclear weapons with IHL prohibition to cause unnecessary suffering. Last, I want to touch on the protection of the environment under IHL and environmental law. Again, in its advisory opinion, the ICJ recalled the Martins Clause, which is codified in all the main IHL treaties. In AP1, Additional Protocol 1, it reads, in cases not covered by this protocol or by other international agreements, civilians and combatants remain under the protection and authority of the principle of international law derived from established custom, from the principles of humanity, and from the dictates of public conscience. Thus, the Martins Clause functions to provide residual protection in cases not covered by a specific rule, and according to the ICJ, forms part of customary international law. It is a clause that has often been invoked in the context of the protection of the environment in armed conflict to supplement existing IHL rules. Increasing concern among states for the need to protect the environment from the effects of armed conflict is demonstrated by the inclusion of specific clauses addressing the issue in international environmental instruments, resolutions of the UN, and the ongoing mandate of the International Law Commission that is looking into the matter. In addition to IHL's specific rules on the protection of the environment, customary international law in respect of environmental law continues to apply in armed conflict. In this context, the ICJ has held that states have a general responsibility, quote, to ensure that activities within their jurisdiction and control respect the environment of other states or of areas beyond national control. This general obligation led the court to conclude that respect for the environment is one of the elements that go to assessing whether an action is in conformity with the principle of necessity, and that states have a duty to take environmental considerations into account in assessing what is necessary and proportionate in the pursuit of legitimate military objectives. Under IHL, the natural environment is a civilian object. As such, it is protected by the principles and rules on distinction and proportionality. There is also the customary international law norm that methods and means of warfare must be employed with due regard to the protection and preservation of the natural environment. It follows that any use of nuclear weapons must also comply with this obligation. Scientific studies and environmental modeling demonstrate that even small-scale use of nuclear weapons would have significant adverse short and long-term effects on the environment and ecological systems. individually and collectively, because the emerging data suggests that the use of nuclear weapons would violate the principles of distinction, proportionality, and the responsibility not to cause damage to the environment of other states or areas beyond their national jurisdiction. A strong case could be made that such use would also be incompatible with the principle of humanity and the dictates of public conscience, given the increasing value that the international community now places on the need to protect the environment and ecosystems for future generations. So I'm going to hand back to Christine to speak to the obligations of the UK under international human rights law.
Christine, if you could unmute yourself. Thank you.
Thanks, Kirsten. I was just saying, I'll just say this very briefly indeed, because of time constraints. International human rights law applies in times of conflict as well as in non-conflict. And human rights bodies have addressed the compatibility of the threat or use of nuclear weapons with, in particular, the right to life. So to quote the UN Human Rights Committee, the threat or use of weapons of mass destruction, in particular nuclear weapons, which are indiscriminate in effect, as Louise has just been saying, and are of a nature to cause destruction of human life on a catastrophic scale, is incompatible with the respect for the right to life and may amount to a crime under international law. The UK is, of course, a party to the International Covenant on Civil and Political Rights. That was the treaty under which the Human Rights Committee was determining state obligations. And the committee continues that state parties must refrain from developing, producing, testing, acquiring, stockpiling, etc., and also to destroy existing stockpiles. They must also respect their international obligations to pursue in good faith negotiations in order to achieve the aim of nuclear disarmament under strict and effective control. So despite the government's professed commitment to universal human rights, its intention to increase its nuclear warheads is not in conformity with the Human Rights Committee's understanding that practices contrary to IHL are also inconsistent to the right to life under human rights law, and that this requires that weapon systems not be developed. And I think as well that, just thinking about the canon of human rights, it's hard to think of any human right that would not be violated by the threat or use of nuclear weapons. But I would like to just finish with a reference to one particular human right, which is that the use of nuclear weapons would also violate the prohibition of discrimination on the grounds of sex and gender, and the requirement of equality between women and men, again spelled out in many treaties to which the UK is a party. Research shows the effects of nuclear weapons have different and disproportionate effects on women and girls, and any threat or use of such weapons would such violate the requirements of equality. And as expressly recognized in the Treaty on the Prohibition of Nuclear Weapons, the catastrophic consequences of nuclear weapons cannot be adequately addressed and have a disproportionate impact on women and girls, including as a result of ionizing radiation. And I think that is another factor that needs to be taken into account when considering the legality of the UK's nuclear policies.
Thank you so much to both of you for these absolutely fascinating contributions. I'm sure you've given us so much to think about, and the breadth of the things we need to think about also, I think, is illustrative of the importance of this topic. If I can pass now on to Kate Hudson, and I know we're all looking forward to hearing from you also, Kate.
Thanks very much, Kirsten. I'm going to just keep this really brief because I can see some great questions in the Q&A, but just to say something quickly on the campaigning angles. I know that we were all incredibly unaware and unprepared for this change in UK policy, and as was said earlier, as recently as 2019, the government was saying, still being very proud of its very gradual reductions and so on. So it was a big surprise. We'd been waiting for the integrated review for quite a long time. It had been delayed because of the pandemic and so on. the government had announced lots of additional spending in the autumn. So I remember having a discussion with colleagues and saying, oh, probably won't be much in the integrated review. They've already announced the increased spending. That's probably it. I mean, how wrong I was. But of course, there are a huge number of campaigning opportunities as a result, and Christine and Louise have really made clear that the incredible range of areas which this is applicable to. And just two things which we are in CND already engaged on as a result. One is around the spending that this is going to incur. I'm sure you've all seen the graffiti and the social media coverage of nurses, not nukes. There was that fantastic piece of graffiti, nurses 1%, nukes 44%. Government says it can't afford to give our health workers a decent pay rise, but nevertheless, they can have this massive, massive escalation of military and nuclear spending. So that's a big thing for us. And we're going to be mobilising at the People's Assembly block on the 26th of June, the Nurses Not Nukes block, and we know many of our partner organisations are going to be taking that message forward. And then, of course, since we've now seen, we have the legal opinion, we know that it's an illegal development. We're now going to begin a campaign to report the UK to the UN for its breach of the NPT. So look out for that, and I hope colleagues and friends and activists will join us in reporting the UK's material breach to the NPT review conference coming up, probably in August of this year. So many thanks, Kirsten. Back to you and our experts.
Thanks so much, Kate, and you're right. There's a lot to do and much for us to think about as we move forward. So that's something that obviously our audience is already doing. We have a number of really thoughtful questions. So I'm going to put these to our panelists. I'm not going to put them to all the panelists for every question, and we'll see how much we can get through before we close at 3. So the first question is from Angie Zelter. And Angie's question is, given the problems with getting the legality of Trident properly heard by the courts because of the royal prerogative and the court's opinion that defence matters cannot be heard by the courts, what can Scotland do through its court system when it believes that it's breaking international law by being forced into hosting weapons it considers can never be used in accordance with international law and is thus implicated in being part of a conspiracy to commit war crimes? And I'm sure that my colleagues in Scotland will be very interested in this legal opinion, Angie, but if I can put that to Christine, first of all, perhaps, and I'm hoping that Christine and Louise will bounce these around between themselves, because I think they'll know better than me who is best to answer each question. And you're on mute, Christine.
I was looking at Kate for that one. I mean, clearly there is the issue that Scottish law and Scottish courts have different systems and so on. And with respect to UK, English, Courts of England and Wales, and I wouldn't want to talk about the situation in Scotland. What I would say, though, is, of course, that under international law, it is the UK that is a party to the NPT, and it is the UK government that is seen as the international state responsible. And so, therefore, any actions that it takes in ways with respect to activities in Scotland, it has to remain accountable for those. Louise, can you add anything on that?
Not really. I was going to see whether we could look around for someone who's an expert in constitutional law, Scottish law, to answer that question. I was like, yeah, not my area. I'm sorry.
I'm confident that there will be people who have that expertise who will be very, very interested in what you come up with. So I'm sure that we will hear more about that. Kate, do you want to add anything to what has been said about this pretty interesting question?
Well, not that, but I have actually just seen a comment in the chat which said, is there not a danger that simply dealing with the cap as a breach of the NPT, that we imply that the UK complies otherwise? And just to say, absolutely not, because can I point you all to Google a 2005 opinion from Professor Christine Chinkin, and that at that time working with Rabinder Singh QC. And the legal opinion found that at that time the decision to replace the Trident replacement decision was itself in material breach of the NPT. So it's kind of not saying everything before was fine, it's looking specifically at this new development, but certainly as far as we understand, the decision to replace Trident was itself a further or a previous material breach.
Could I come back in on that again as well? Which is that, the NPT has now been enforced for what, since 1970? So we're talking just about 50 years. And there haven't been these negotiations in good faith towards disarmament. And the International Court of Justice in the nuclear weapons, legality of nuclear weapons case, says that the obligation to negotiate is an obligation of result, not just an obligation of conduct. And while one cannot assume from the fact that there have not been successful negotiations that there is necessarily breach, at the same time, that fact that unilateral statements are being made, there doesn't appear to be that intention to ensure such obligations.
I think that's really helpful, and it's useful in us thinking around this topic. And perhaps our next questioner somehow knew that we'd be talking about things in this way, because the next question we have is from Nikki Davis, and Nikki says that the last time they wrote to their MP about nuclear weapons, the MP stated that his government was committed to reducing them. Is there any point in writing to the MP again? And if so, is there something more in layperson's terms that could be put to the MP? Kate, that is definitely one for you, but I won't be able to resist coming in after you.
Okay, yes, definitely get back to your MP, Nikki. They say these, no disrespect, Kirsten, obviously you're not an MP like this, but many MPs just try and fob you off and send you a kind of duplicated thing from their party office and so on. So yes, do get back to them. And also, if you look, I've read the legal opinion, and I'm not a legal expert in any way, shape or form. I'm a campaigner, and there is plenty in there which is in layperson's terms. It's really, really clear. You don't have to use all the quotes of sources and all that sort of stuff, but do have a look, and I'm sure you'll be able to quote directly from the opinion to your MP.
I would absolutely endorse that. I think that there is always a point in writing to your MP on any matter, but particularly on this issue. And I would not be too troubled about what kind of terms you put it in whatever terms suit you, put it in your words. And actually that is probably the most powerful thing that you can do, because that's going to be a unique piece of communication from you. And so they'll have to respond to it as a unique question. And actually that advice applies whether your MP is likely to be happy or less than happy with your perspective on this, because the other thing that's worth bearing in mind is that if your MP is somebody who might find themselves in the audience or even on the panel at an event like this, they might want to know that you are interested in their position also. So all of that is powerful in trying to move this discussion forward. And I hope that you get a helpful response back, Nikki. The next question we have is from Ben Donaldson. Ben is asking, given that the integrated review is inconsistent with NPT obligations, would a legal challenge to the UK's new nuclear posture be likely to be winnable? So I'm definitely going to bounce that one, I think, to Louise first and then Christine. And again, I'm hoping you'll bounce it between you as you see fit.
How did I know it was coming to me? Okay, so I really have a question back to Ben, because there's an assumption here, and I'm not quite sure, whether he's already got somewhere in mind. But my question is, which court system are you looking at? Are you looking at domestic law? Are you looking at international law? Because the answer would clearly be different. Clearly in domestic law, we always confront that problem, that barrier, where matters pertaining to defence and security are always given, the executive are always given deference in courts, and I think we're likely to be sorely disappointed at the international level. I'm not entirely sure that that there will any result, even if a legal challenge was possible in any forum, including, for example, the ICJ. Let's say we get, through the sort of various hurdles that the ICJ has historically not been keen to pass judgment on issues like this. So I'm not. Can I bring my colleague Christine come and rescue me on this one? Because I'm a little bit more, I think, skeptical that the law is going to exist. I think this is a political decision.
I'd agree totally with Louise on that. So two things I'd just add. The reservation to going to the International Court of Justice, the reservation that I read out earlier, it has been entered by the United Kingdom specifically to try to avoid another case like the one that was brought by the Marshall Islands a few years ago against the United Kingdom and other nuclear weapon states relating to the legality of Article 6. At that point, the case was dismissed on the basis that there wasn't a dispute existing between the Marshall Islands and the United Kingdom, which many of us, I think, thought was a highly technical, very narrow understanding of what constitutes a dispute under international law. But the UK then moved following that case to try to ensure that such a case could not be brought again. And so that means at the international level, the most likely would be another advisory opinion, such as the advisory opinion that we had in 1996. And I'm sure many of you know the sort of various controversies around the 1996 advisory opinion. And of course, the fact that following it, it hasn't led to a change of policy in the nuclear weapon states. So, as I conclude with Louise, I think the law is important. I think the law is important as a backing to political arguments. I'd be interested in Kate's view on that. But in terms of legal challenges in a court, I think that, again, it is unlikely to be successful.
Thank you both for that. Kate, would you like to come in there?
Well, yes, actually. I mean, when was it Louise, I think, said this is it's a political matter. This is a political decision, and the government will find ways politically of pursuing it. And it just reminds me of in 2002, I think it was, when the government at that time, Blair's government, was wanting to go to war in Iraq. And CND took a legal challenge on that, whether it was legal to go to war on the basis of UN Resolution 1441. And we sort of got so far, and then it was ruled in some divisional court, I think it was, that it was non-justiciable. Well, surprise, surprise, they're not going to allow that to happen. So I think that, I think it's absolutely brilliant to have this opinion, because we are the law is on our side, and we will use that argument in our political work and in our campaigning. But I don't expect, unless there's some massive revolution in how things are done in our society, we're not going to win in the courts on this kind of level, because we are up against the government.
I suspect that's why these other discussions are so important, and why the question about people corresponding with MPs really matters, because there's obviously perhaps a quite different perspective on this, maybe where I'm sitting in Scotland, but I think that overriding principle of making sure that people who sit in positions of power know what your views are on this really, really matters, and this legal opinion will be so helpful in all of that work. So we have time for hopefully another question, and we'll see how we go on, maybe more. Janet is asking, is there an argument for highlighting the UK's breach of Article 1 via the MDA with the US and support for the Israeli system, as well as Article 6? So can I bounce that first of all to you, Kate, and then we can possibly bounce it to our other panelists if they wish to come in. Oh, I wonder. Oh, Kate, you're on mute.
Sorry. That just obscured my hesitation in answering. I'm not quite sure what the Israeli system is. But I mean, the MDA refers to the Mutual Defence Agreement, which is the US-UK's incredibly extensive nuclear sharing policy. It's been around since 1958. It underpins our nuclear relationship with the US and so on. It's also thought by some people to underpin our sort of sometimes slavish loyalty to US foreign policy and so on. And in actual fact, the ratification or the renewal of the Mutual Defence Agreement, which was due in Parliament in 2024, I think that was actually specifically referred to in the integrated review. So that's something that we need to have on our radar. And I think that we should always be exposing and sort of repeatedly raising public awareness about all those ways in which we are tied into US nuclear policy, US foreign policy, and the way those things are in breach of the NPT, for example, you know, that we have this cooperation on nuclear weapons and all that sort of stuff. So I think any way in which we can raise awareness of those things and use them in our work, yes, so much the better.
I think that's really helpful, Kate. Would either of our other panelists like to add anything to that?
I would just add that I think it's a very good example of where legal argument can both be very technical and textual, which is very much what both Louise and I did with, you know, the close analysis of Article 6. What does it require, and what is the general what obligations does it set out, and what behaviour would then be in breach of Article 6? And likewise, the way Louise analysed proportionality, necessity, these legal doctrines. But underlying all of this is this overwhelming importance of the object and purpose of the whole legal regime. And quite clearly, everything Kate has just said goes very much to looking at behaviour that in different ways undermines that object and purpose. And I think that legal argument can also be extended out in those ways to support the more technical textual analysis. And I think that is important. And I think perhaps that's where politics and law also comes together in some ways.
Thank you so much, Christine. Louise, did you want to add to that?
Yeah, can I just jump in with one other thought, which was an issue that we did not deal with in the opinion, and it's transparency. And I think one of the commitments that the UK has entered into, certainly through the review conferences, is transparency. And transparency is the one thing that it says it is now going to reverse its policy on, okay? In other words, it is not going to share. And I think this sort of is a really important issue that is worth perhaps pursuing legally, but also politically, because it's about a democratic society and accountability. And it goes to so much about what kind of society we want to live in that is much more than simply nuclear weapons. And I think it's a dangerous step to take, but it's one that perhaps CND would like to ponder on in terms of strategies as you move forward.
Thanks so much. I think that's a really interesting point to stop on. What kind of society do we want to live in, and what does that mean for all of the discussions that we've been having? Yeah. You know, it really comes down to the real fundamentals. And I see that Janet has very helpfully put in our chat that it would appear that the upping of the stockpiling has already begun, you know, which is a pretty sobering thought. But thank you to everyone for giving us all of these great questions. I'm sorry that we didn't quite get to all of them, but it's clearly going to be an ongoing discussion. A huge thank you to both of our very eminent panelists for their really interesting input and for all the work they put into that legal opinion. And as always, thanks to Kate for being so thoughtful as she goes through all of this with us. And if I could also thank the team at CND who put this together, because they did a great job, as they always do. So I hope that it has been as informative and interesting for everyone who is listening as it has been for me. And I'm sure that we'll carry on carrying on. So thank you all.
Thank you.
Thank you. Thanks.
Thank you very much.
Thank you.